not hearing anything. Oh, God.
Oh. Thank you for that note. I'll just restart. I'm Matt Williams, City Planner for the City of Ellsworth. Tonight, I'll just be covering drafting land use ordinances and some tips and tools that town staff, selectmen, planning boards can all use to make changes to your land use ordinances and some best practices in doing so. The agenda for my presentation will be, what's a land use ordinance and why do we have them? There are different types of land use ordinances and the pros and cons of each. Then we'll go into a bit of the process in drafting your land use ordinances. Then we'll do using your comp plan to inform these changes and decisions that you make. And we'll end with some questions from the audience. So first, what are land use ordinances? Land use ordinances are a scheme of municipal-wide zoning regulations that guide allowable uses, performance standards for those uses, and dimensional and density requirements for lots. So, you know, a lot of our municipalities will just have kind of a paragraph form for their for their zones, and then the types of uses they allow in those zones. But my preferred way is using a table of uses where you kind of have your zones lined up in columns and there's rows with the different uses, and you just say yes or no as to whether that use is allowed in that particular zone. I just think it makes it clearer for people who are purchasing land and trying to figure out, you know, what they can do with that property. It also makes it easier for myself as staff to quickly reference the table instead of reading through a bunch of paragraphs of text to figure that out. If you want an example, if you go to Ellsworth's ordinance pages for our chapter 56, article 3, that's the table of uses is in there, and that shows you what a table would look like. And then land use ordinances also assist the community in building out the desired balance of development and quality of life. In a very general sense, these laws help promote the public health, welfare, safety, and common good. That's always the goal of land use decisions that we make. You know, it's not to benefit one person in particular, it's to make sure that the community is healthy and growing in a responsible way. Why do we need land use ordinances? So again, it's twofold. A lot of people think that if you have more ordinances, there's just more restrictions on people, limits individual rights with their land, but that's not necessarily true. Because a lot of developers enjoy having clear code and understanding of what's allowed on their property. So it's a balance of providing safeguard and expectations from the community, what the community wants, where they want certain things, how they want certain uses done. And then developers know that if they're written well and properly by staff or professionals, it clearly explains these expectations, and it'll help them protect their investment in the community, because they know if they're building their project to a high standard that the community has, you know, their neighbor isn't going to be able to build, you know, a lower quality product and lower their investment value later on. So in types of land use ordinances, so in Ellsworth, we have a unified development code, which is a larger set of provisions packaged under an umbrella ordinance. So again, we have our chapter 56, which is the unified development ordinance. And then within that, we have different articles that kind of cover different aspects of that development code. And so you have but you have one set of definitions for that entire chapter 56. So every time you use a phrase or a word, it means the same thing throughout it. You just define it in one place, so you don't have to have multiple single ordinances with different definitions within each one. But then it walks through your processes, it walks through your expectations. There's a table of uses again mentioned in there. And then you can break it down into more specialized areas too, where we have like a parking standard for different types of areas in towns. Like our downtown has a different parking standard than, say, our normal rural zone, just to facilitate, you know, again, the character of the neighborhood or the zone that you're in. You know, downtown has more public parking, so businesses down here helps encourage development and lower development costs. They can share, they get the bonuses for being downtowns to share that public parking. They don't have to build parking themselves all the time. So things like that. And then the singular ordinances are more there's uses for them too, where it's specifically based to a particular issue or a topic, and it's very niche. Smaller municipalities might find this more useful than a unified development code. But if there's like a particular hot button issue in your community that's related to development, you may just have a singular ordinance covering that topic instead of a wide-ranging unified code. And then continue on. So within those two ways to organize your code, there's use-based zoning, which is I think what most people are familiar with. It's formulating zoning standards based on allowable uses and locations determined by the most suitable land for those uses. So it's what you're used to seeing, like a rural, industrial, commercial, and residential zones. They may have different names, but like they're based on those types of uses for the most part. But more recently, there's been like a push for form-based code, which is an organization of uses based not only on where a specific use should be allowed, but also how that would impact the physical appearance and character of a neighborhood. There are a lot of examples of that going on in Maine now, but also across the country in terms of, what uses do you want to have in a neighborhood, but then if that use is going to be allowed, what should that facility look like? And it's usually around beautification standards and also what the exterior of the building looks like, so that it's not awkward to have, your historic downtown may have like protections for those buildings, but then a block over is, a McDonald's or something. But an example is the McDonald's in Freeport would be an example of more form-based code. I don't know if they exactly used that, but again, it kept with the character of the town and the neighborhood that they were in, and they wanted to maintain that appearance, while allowing, that use to come into the community. So the process: who is responsible for drafting land use ordinances in your town? Your planning board or selectmen or council could be, depending on your style of government. So like in Ellsworth, I'll give examples later. It could be staff, so your planner, your code enforcement officer, or your town city manager, or paid experts, so your town attorney or consultants, or HCPC provides technical assistance as well. So in Ellsworth, our process is myself as planning staff will draft the original ordinances. I will usually confer my first set of drafts with our town council, not our town council, our town attorney, our city attorney. They'll take it to the planning board. Planning board will review these first drafts, make their changes and recommendations. And after a few rounds of that, they'll either vote to recommend to our city council or continue to work on them at each meeting. And then once they're recommended to city council, I'll go back to our city attorney, say, here's, the changes that the planning board made to our last first drafts, like review them, let me know what you think. We'll talk them through. And then I will then take them to the council for recommendation after that, or for approval after that, and the council will review and then approve them. And after that full process, it's usually pretty quick for the council to just say, all right, it's been vetted enough times and everything looks good. But regardless of who drafts the original documents, land use ordinances should always be reviewed by an attorney before adoption. These are laws, and there can be a lot that goes into them. You'll hear later about state laws that require municipalities to kind of change your land use ordinances, and so those can be kind of complex if you're not used to working with the law. And so hearing from attorneys or another paid professional is very helpful, but in that process. So another thing to get used to is that nothing you draft will be perfect. Ordinances are meant to be revised and updated. The law shouldn't be static. It should be changing with your community and as your needs change. You can't necessarily think of everything or catch everything in your first go around. People find loopholes, people get creative, and like different problems show up. I mean, COVID presented a whole host of problems that nobody could really have seen coming. And so laws had to kind of adapt to that in real time. So it's just an example of ways that the laws should be changing fairly regularly. You should be reviewing your land use ordinances on a semi-regular basis. And it's always more helpful to kind of break them down into sections instead of trying to do it all at once. But the more revisions you do, the more expensive the ordinance is to maintain. But it's better to admit mistakes than let problems persist, because it could be costly in the long run. And you never know if you're opening yourself up to possible legal action. And so paying the attorney to review land use ordinance changes is cheaper than going to court over something. But just, as long as your land use ordinance drafts are based in good practice, and again, if you are reviewing it with your attorney, they should be able to help you do that. The changes should be kind of brought up by the community and not because of large issues that pop up unexpectedly. And then one trick that's pretty useful to use, at least, but not great to rely on exclusively, is borrowing content from other municipalities. It's a good way to get ideas flowing, to see what's worked in communities you may deem similar to your own. But land use ordinances are very specific to the municipality that they're in, and a lot of times they have their own internal logic. So like, again, like you go back to those definitions, you may hear a phrase and you think you know what it means, but that municipality may define it in a very specific way. And so if you just try and borrow one section of their ordinance that uses that phrase without, comparing to their definitions and how your ordinance defines something, it could end up meaning two very different things, and you might get in trouble with that. And then you have to ensure your ordinance does not contradict state or federal law. Again, this is why you reach out to an attorney or a paid professional to help you review them. Because home rule does have its limits. Like most municipalities do have the freedom to regulate most things, but the state and federal law do have their own restrictions and things you have to be mindful of. But the good news is that usually if there is state or federal law that controls something, the state will often provide guidance on definitions and requirements that have to be incorporated into your own land use laws. So when drafting, you want to avoid terms with negative connotations. I know like there's been a push, mobile home is no longer a popular term to use. Ellsworth is guilty of having it within our ordinances still. Manufactured housing is now a preferred term. So just trying to use equitable language that most people, doesn't have a certain connotation to it that would isolate people or not want them to do a certain project in your community. And then when all else fails, words can mean many different things. It's impossible really to define every word in your land use ordinances. But Ellsworth is recently going to add a note to our definition section where we align our definitions with plain English from the Webster's dictionary, and we put whatever additions, the most recent addition in there. Just so like if there is a question about a phrase that does not have a definition within our ordinance specifically, there is something that people can go to reference with, and it's an easy Google search away to find out what that definition is. And then you make sure your ordinance is realistic. There's a lot of needs in communities, but there might not be staff or the time to handle those needs. So what can your staff handle in terms of enforcement and capacity? This is particularly important on the code enforcement side. I work a lot with our code enforcement office on talking about, what's possible with these LE 2003 updates. I'm allowing the community to dip its toe into short-term rental regulations. We're doing a housing study to see if more broad action is needed on that topic. But for now, it's something that will affect a very small number of properties, if at all. And our code enforcement office could handle that uptick in extra work. However, if we did something more broadly immediately, they're an office of two, and they already have enough work on their plates that having to regulate short-term rentals would not really be possible. We'd have the laws, but there'd be no enforcement, and essentially then the laws would be empty. And so just keeping that in mind for your staff's well-being, but also just what kind of message would you be sending to the community if there was a law but nobody was enforcing it? It just kind of looks like the government's not doing anything to protect its citizens. And then you have to remember that ordinances serves a wide range of audiences. Whether it's just a average person, resident who's trying to build a shed, a local developer starting a business, or a big box store like Walmart or Target, who has a highly paid team of engineers. Everyone needs to be able to find the ordinance accessible. So as you go through these ordinance updates, it's good to have public input. If you have a surveyor or an engineer who regularly comes to your planning board, ask them if they don't mind reviewing it or reading it to make sure they understand it. You don't want to let them have too much say if they have an interest in one idea or another, but at least ask them if they understand what you're trying to convey. And they're usually willing to do that. So using your comprehensive plan, I know a lot of municipalities in Hancock County are going through the reviewing or updating process for comp plans right now. And that's a good thing because the comp plan is a legal basis for your land use ordinances. Ellsworth is currently updating our comp plan. I think we're 20, no, the last comp plan we did was 20 years ago. So we're like 10 years behind on the update. But so there must be consistency between the findings in your most recent comp plan and your land use decisions that are made. Because that's the comp plan is really where the community says what they want, the vision they'd like to see moving forward. And it is your legal basis for saying, this is why we're making this land use decision. The community provided us with this information previously. And then again, they'll likely, again, if that comp plan remains true and there's not too much demographic change or goal setting change in the community, that'll, when you do your public engagement through the update of your land use ordinances, again, that suggestion from the comp plan should mostly still be the same as the present day feedback. And then there will be a relationship between the future land use plan created in the comp plan and your zoning district map used by the city. And yeah, so like you'll see a reflection of the comp plan, the public input. Part of your comp plan should include a future land use map or plan, and then your zoning map that your city uses to, again, guide development and guide your land use decisions. And then the goals established in the comp plan will determine the purpose of each zoning district and its allowed uses. You know, your zoning districts may change, their names may be updated. You may add a zone because you realize that there's no buffer between residential uses and industrial uses, and it's turned out not to be a great thing. So it allows you to, the comp plan really is the freedom for the municipality to determine their future and what they would like to see in their community. So there are my resources that help make this presentation. I'll see if there's any questions in the chat. Doesn't look like it. So if there are any questions, if anyone wants to raise their hand, feel free. Jim, I see you've raised your hands. Do I have to unmute you or can you do that?
I'm unmuted. I see I'm also on the camera. You know, thank you for your presentation. I think it covered a lot of ground in a short time. I've been really intrigued by performance-based zoning, which you didn't mention. You had form-based, which I'm afraid some people think replaces use-based, which it doesn't. It just enhances use-based by adding other envelope considerations. But performance-based really intrigues me because then you're looking at how that use would impact a place more than exactly what the use is. And it would allow for greater mixed use than a lot of the form-based and use-based zoning we have now.
Yes, do you know any municipalities that currently use performance-based on a regular basis?
Not in Maine, and I think probably it's usually some hybrid of, you know, here's the use, but and there are a lot of times conditional use. You can have a home-based business, but if you have too many cars, then you're impacting your neighbors, and we might take away that use. We may not allow you to because you're having a negative impact. But it allows someone to try something like putting a home business in a residential area to see if it'll work.
Yeah, that's a good point. I mean, Ellsworth, wouldn't call it performance based on its own, but our neighborhood zone allows for specific like at-home uses, businesses to be run, but the requirement is that they have to have like a certain number of cars or less. Like you can't have client visits that exceed a certain number if you're going to be allowed to have that business out of your home in a neighborhood zone. So it's not quite, it's similar to performance-based, but it's in Maine. Any other questions? If not,
I've got a question. I work with a community that is very resistant to zoning, but they have one particular neighborhood that they want to do essentially land use. I got the impression at the beginning of your speech that it has to be the whole town wide in order to be legal. But is there a way to do some sort of really vague rural area for the rest of the town and still focus in that one area?
I think it would, I'm gonna give you a very lawyer answer, it depends. Um, so there's such a thing as spot zoning, so if it's too small of an area, you would be, I think it could technically be considered spot zoning, which is not encouraged or really allowed. And that could be challengeable, but if it's a broad enough area, I mean, if you're gonna go through the trouble of zoning one specific part of town, you might as well look at maybe possibly zoning in the rest of it, depending on how large your municipality is. But you may get a better answer from one of our later presenters, who is actually an attorney. So it might be worth asking that question again. Any more questions? If not, then I'm not sure how Brian or Ben's gonna do his presentation, but.
Okay, so our next presenter is via Zoom, Ben Averill from the Housing Opportunity Program under DECD. I'm going to stop my share so he can share his screen. Hopefully this works.
Give me 2 seconds and I'll get the feed up. I wasn't sure how you were going to do it either.
Details. Make a last minute change, so.
All right, hopefully you can see that both in Zoom world and at the Ellsworth Town Hall.
Looks good to me. I think we're good.
Perfect. So I'm Ben Averill. I'm one of 2 coordinators for the Housing Opportunity Program in DECD. And I'm going to sort of play off of the conversation that Matt had just kicked off on building out ordinances and what ordinances are. So I'm going to talk about what's kind of been a hot topic over the last year or so, which is LD 2003. And primarily we'll talk about how to think about implementing provisions of LD 2003 into your local code, but I'll do a little bit of a background on what LD 2003 is as well. So LD 2003 was signed into law in April of 2022. And that the law was intended to increase housing opportunities in the state of Maine by allowing municipalities to amend or create new zoning districts that would essentially create housing opportunities. It was really focused on removing regulatory barriers to housing production, and it came out of a several-month process where the state had engaged with a commission to look at zoning provisions and ways to think about amending land use provisions across the state. Broadly, LD 2003 has 3 different statutes. Those statutes are all individual components. One allows for additional density for affordable housing development. One has to do with increasing density on regular house lots. And then the third one has to do with accessory dwelling units and allowing accessory dwelling units across the state. LD 2003 also has provisions regarding statewide housing production goals, which will be established in the near future, as well as just some framework around the Fair Housing Act, and that as municipalities, we should be trying to structure ordinances based on the Fair Housing Act. As I mentioned, a lot of this slide deck will not go into the weeds of LD 2003, but I'll give you a little bit of a framework for what LD 2003 is. So the LD 2003, as I mentioned, was a culmination of conversations focused on land use changes the state could make and trying to figure out how to address some of the housing shortages that the state was realizing that we were going through. Earlier this month, my department, in sponsorship with Maine Housing Authority and the Governor's Office of Policy, Innovation, and Future, released a housing production needs study, which was part of LD 2003, which estimates that we currently have an underproduction of about 37,000 units across the state, and that by 2030, we're expecting that we would need 75,000 to 83,000 units, and that's across the state. So we knew pre-pandemic that we were having a housing problem and a shortage of units across the state, and it has only gotten worse since the pandemic started. So broadly speaking, as I mentioned, LD 2003 was focused on removing some of those regulatory barriers to help create additional housing across the state, while also making sure that communities could create land use plans that continue to utilize comp planning and master planning to protect sensitive environments, regulate their housing developments based on water and wastewater capacity, and then enforce shoreline zoning or choose to create a rate of growth ordinance. There's a lot on this slide, and I apologize for that. But this slide goes through the 3 different statutes of LD 2003, or as myself and my colleague in the Housing Opportunity Program talk about them, the 3 different buckets. I'm really only going to touch on a very high-level overview of what these 3 statutes are, but if you're interested in learning more about what they are, we've done presentations with HCPC in the past about LD 2003, and my program is more than willing to speak with each community separately if that's helpful as well. The affordable housing density bonus is 30A MRS 4364, and that creates an automatic density bonus for affordable housing developments of 2.5 times the base density, as well as requires a parking reduction of 2 spaces for every 3 units in that affordable housing development. And you can see below that the qualifications that a developer has to meet in order to be able to receive that density bonus. The second statute in LD 2003 is 30A MRS 4364A, which has to do with up to 4 dwelling units on a lot. And what that statute requires is that a municipality needs to allow between 2 and 4 dwelling units on a lot where residential uses are allowed. The number of units that are allowed will depend on whether that lot is located in a designated growth area or has public water and sewer. And the intent of this statute was really to prohibit single-family zoning throughout the state. So any area where there's a residential use allowed, there needs to be a greater use typology greater than single-family zoning. So at least 2 units need to be able to be placed on a lot anywhere where residential uses are allowed. Additionally, it allows for an existing dwelling to have up to 2 units that are placed within on that same parcel. And lastly, the ADU provision, which is 30A MRS 4364B, requires municipalities to allow 1 ADU on a lot where a single-family dwelling is located and where a residential use is allowed. And below that, you can see the provisions for an ADU. There were communities prior to LD 2003 that had ADU ordinances on the books, and it probably makes sense if you're a community that already had an accessory dwelling unit ordinance to review your ordinances just to make sure that you are meeting those guidelines, which again are on the screen, but there's certainly more provisions that would be helpful to look at as well for that. Each community has to have these provisions implemented into their local land use components or any local permitting by specific dates. January 1st, 2024 is the date in which communities that utilize town council or some other elective body that is the body that approves ordinance changes. And July 1st, 2024 is the date in which communities that use town meeting to adopt ordinances need to have all of the provisions implemented into their local ordinances. So post LD 2003, what can a landowner build on their lot? A landowner can build an attached or detached accessory dwelling unit on a lot where there's a single family dwelling unit. A landowner could potentially build a duplex on a lot where there's a single family home, or on a vacant lot that doesn't have access to public water and sewer and isn't located in a growth area. Or they could potentially create a quadplex, which would be 4 units on an empty lot located in a village center which is designated as a growth area. So that was a quick overview of LD 2003. I apologize for how brief that was, but I wanted to make sure that we got into that a little bit and then talked about how you can start to implement LD 2003 into each of your communities. So as you heard in the first presentation, there are different ways to structure both your zoning provisions and any local permitting. So the first step in making these amendments to your local codes is just to understand what you actually have as local ordinances. So review any land use ordinances and zoning maps that you utilize, review your shoreline zoning ordinances. If you have a comprehensive plan, take a look at a comprehensive plan. For LD 2003 purposes, we are recommending that you look at any of comprehensive plan, whatever your most recent one is, even if it's not, even if it is out of date according to the DACF state guidelines, that we would recommend utilizing that comprehensive plan, the last one that you've done. So if you think back to a couple of minutes ago when I talked about those 3 statutes, generally those 3 statutes apply in specific provisions. So going from the left to right, the affordable housing density bonus only applies to municipalities that have zoning, and then municipalities that have zoning where there is adopted density requirements and they permit multifamily housing, as well as have either a designated growth area in their comprehensive plan or public water and sewer. The up to 4 dwelling units provision, which is 4364A, applies to all municipalities in the state of Maine. The number of units that could be placed on a lot depends on whether that lot is within a designated growth area or if that lot has public water and sewer, if you are a community that does not have a comprehensive plan. And the ADU provision applies to all municipalities across the state. So once you have determined what land use provisions you have in place, if any, and once you have determined which of those buckets on the previous slide are applicable for your community, what you need to do is start to amend your draft and start to amend your land use documents or local permits. How involved that process is really depends on the complexity of your local land use provisions and your permitting process. And there are certainly communities across the state that may have minimal, if any, and minimal or may not have to make really any changes to update their documents to comply with LD 2003. So questions to consider as you're thinking about making land use amendments or permitting amendments to comply with LD 2003 is, does my town have zoning beyond shoreline zoning? Does my town have an established density requirement or lot area per dwelling requirement? And what is it? Do we allow multifamily housing and where? If we have a comp plan, where are our growth areas as laid out in the most recent comp plan? If you have public water and sewer, where are those located? If you don't have, or whether you have public water and sewer or not, identifying if there are comparable systems, which would be a private system that could work like a public system. Understanding if you have any parking requirements for multifamily housing or for single family housing. Understanding where you allow residential uses, including as a conditional use. Having a good grasp on what you utilize for a non-conforming lot, and then having provisions for adequate water and wastewater. Additionally, understanding your parking requirements and what form of government you have as well. So this slide here is provisions related to maize. So everything that I've talked to you earlier in this presentation are things that towns are required to do as you're thinking about LD 2003. LD 2003 did have a couple of provisions that were a may provision instead of a shall provision, which means a community could choose to implement these provisions. And they are laid out on the slide in front of you by the particular statute. But generally speaking, a community could choose to be more permissive than any of the statutes, so allowing more density or more development than what state statute is requiring. You could establish permitting processes or violations and fines for any of the 3 statutes and any of the provisions are related to those statutes. You can allow a less restrictive criteria for variances for any of the 3 statutes. Specific to ADUs, you could also have specific performance standards around the ADU, or establish a maximum size for the ADU, because the state statute only establishes a minimum size for an accessory dwelling unit. In general, you could think about how to think about short-term rentals and how they relate to any of these new developments that a landowner could create. So switching gears one last time, I have 3 different examples that kind of go over what that could look like. So Town A has zoning and 3 designated growth areas. It also has public water and sewer and a 200-page land use ordinance document. In order for Town A to comply with LD 2003, they would need to comply with all 3 sections of the all 3 of those buckets, because they have a designated growth area, they have public water and sewer, and they have density requirements, and they permit multifamily housing. So they would want to review all of their 200-page document and review any permitting processes that they have. And they may need to add new definitions or amend existing ones to conform with state statute, as well as amend provisions that are new, like the affordable housing density bonus. They may need to think about their land use tables and dimensional standards, and how the 2 of the 3 provisions interact with what they have on the books. And they may need to think about how ADUs are permitted on a lot if they have an existing ADU ordinance. Generally, they would not need to update their shoreline zoning, but they would want to confirm with DEP that that shoreline zoning still meets those requirements. Example 2 is Town B. Town B has shoreline zoning, and then they categorize the rest of the town under one large general zone. Town B does not have growth areas because they do not have a comprehensive plan. They also don't have public water and sewer. They do have specific ordinances that follow state subdivision law, some general use provisions under their general zone and shoreline zoning, and they have a planning board. So in order to comply with LD 2003, that town does not have to meet the first bucket, the affordable housing bucket, because they don't have a designated growth area or public water and sewer. They would want to review any of their land use provisions and make sure that their ordinances meet state statute. And they may need to update or amend their existing ordinance to ensure that any area that has residential uses allows 2 to 3 dwelling units on a lot. And that might mean updating use tables or dimensional standards and reviewing provisions related to the ADU. They also may want to confirm with DEP that they do not need to make any changes to their shoreline zoning component, but generally speaking, shoreline zoning should still be all set. And lastly, Town C. Town C has shoreline zoning, but does not have any other zoning. They have a building permit ordinance in which they have a building permit process with the code enforcement office, and a parking ordinance. They do have growth areas as defined in a comp plan, but they don't have public water and sewer. So that town would not need to meet the requirements of the affordable housing density bonus because they don't have zoning or density requirements. They would need to comply with the other 2 statutes, the additional dwelling unit and the ADU component. They would want to ensure that their building permit ordinance and any permits that they have meet requirements related to LD 2003. And if they have anything in their general land use ordinance, they would want to review that to make sure that if they use a use table, that any use provisions would match what is required under state statute. They certainly could choose to create a more detailed land use ordinance, but what they have in place may be sufficient. And generally a town such as Town C may have the least amount of provisions to amend solely because they have the least amount of regulations on the books. And then just like any other community, they would want to verify with DEP that nothing needs to change in their shoreline zone. So hopefully going through that really quickly, you have taken away that every community in Maine is unique. As it was mentioned in the first presentation, we are a home rule state, which means generally most communities can choose to regulate land use in a manner that makes sense for them, which also means that when you're thinking about LD 2003, there may not be a specific right way to comply with LD 2003. You'll want to make sure that you're tailoring ordinance development processes and permitting processes to what makes sense for you as a community while complying with the minimum requirements of state statute. And if you have questions on how to make this process work, or if you have questions on what you are starting to draft and if it makes sense, certainly reach out to your local planning organization like HCPC. Feel free to reach out to my program, and definitely would recommend speaking to legal counsel as well. And then that's my information, and I believe that's going to be shared with folks if it wasn't as well. And I will stop sharing for now so that we can take questions if that's helpful. Tim Fisher, I see your hand. Go ahead.
Needless to say, I always have questions. One is, a lot of towns have adopted shoreline zoning ordinances at some point, and those are constantly changing or changing periodically at the state level. Has LD 2003 caused the state to rethink any of the shoreline zoning ordinances? Do we need to look at that?
The state is doing, there are many provisions related to how we think about growth management throughout the state that are being reviewed currently. I do not believe shoreline zoning is one of them, but I do know that DEP has reviewed these provisions. And I breezed over a bill that went through the legislature this past session, but LD 1706 had provisions that clarified some challenges that my department had noticed with the way that DEP was looking at shoreline zoning. And I breezed through what LD 2003 does and doesn't do, but it does require that each community continue to move to utilize shoreline zoning requirements, either the standard shoreline zoning requirement or the requirement that you have approved through DEP.
And one other quick question. There is funding for towns to do this. Would you mind explaining that process, how towns would apply for it?
Sure, I'm happy to. Generally, we talk about that in our big presentation, but I wanted to get through ordinance development stuff for tonight's presentation. But my program, the Housing Opportunity Program through DECD, does have funding for a couple of different provisions. We have funding for strictly for municipalities to do exactly what I talked about tonight. So to do ordinance development work related to LD 2003. If you're interested in learning more about that, you can go to my webpage, which is on my last slide, or you can shoot me an email and we can get you information. But generally, communities across the state are eligible for $5,000 or $10,000 to do work towards amending their local ordinances to comply with LD 2003. And we also have separate funding for grant components, both for service providers as well as for municipalities. And if you want to know more about what our funding processes are, definitely email me or give me a call and we can chat about what funding DECD has for housing provisions throughout the state. Are there any more questions? If you do have questions, feel free to use the raise hand feature.
I guess we'll go on then. Thanks, Ben. We're going to take a moment to share screen and get that figured out. But up next, we've got Stephen Wagner, who's a land use and environmental attorney with Redmond & Winchell. He's going to talk about legal considerations and ordinance development.
Oh, good evening. My name is Stephen Wagner. I'm with the law firm Redmond & Winchell. I am part of a municipal and land use practice group that serves about 36 plus municipalities or districts, quasi-governmental entities, as well as counties throughout the state, primarily the Hancock, Penobscot, Aroostook, Washington County, Waldo County, Piscataquis County, and some southern communities as well. And then, of course, we also represent developers on the other side. And as many of you in this presentation probably know, land use practice in Maine often means municipal practice. Most of the control of land outside of certain state statutes for projects typically of a larger size are really controlled at the municipal level. So for most people and even most businesses, their interaction when they're considering what they can or can't do with their property is going to be at the municipal level. And the way that municipalities can exert some control, if they want to exert any control over how land can be used in their community, is through ordinances. Because while you could, at say a town meeting, put an article on the warrant that says, "Thou shall not have a movie theater in my town," that may seem on its face to be sufficient, but for various reasons that we'll get into, that would not be a enforceable ordinance, let alone one that really gave much guidance to anybody about what was allowed or how that would operate. And so that's essentially the role that municipal ordinances play. So I have the benefit of going last, so I get to skip a lot, and that's what I plan to do. So I'm just going to touch on some of the major legal considerations that come in here, and feel free, anybody, I don't know if I can see it, but I'm sure somebody can flag it for me if there's a question in the middle of while I'm droning on about something. Please God, just interrupt me and ask away. I'd much prefer to do that than save it all for the end. So as a general principle, we've been talking a lot about zoning, and so zoning is authorized by Title 30A pursuant to municipalities' home rule authority, as we've discussed. But I think one sort of nuance I think I can add to the conversation is that there's actually a bit of a distinction between zoning and land use. And so zoning is as Matt was discussing, traditionally came out of the use-based form of zoning, or the Euclidean zoning. And so you have the division of land into districts, and then a provision of what uses are allowed in those districts. And if you do that, according to statute, you need to go through a process, a specific process for enacting those ordinances, as well as having critically a comprehensive plan first. And that land use ordinance must be adopted pursuant to and consistent with that comprehensive plan. But zoning is just one part of the overall universe of land use ordinances. And so you can have a land use ordinance without having a comprehensive plan. So you can have commonly what we would see as a commercial site plan review ordinance, which provides certain performance or form standards to particular uses, but it doesn't dictate where those uses are or are not allowed. The other thing I think to emphasize here is one of the basic principles, legal principles to keep in mind in zoning and land use, is that zoning and land use ordinances are what the courts have called an abrogation of the common law. And what that means is that under the common law, or long before we had legislation that was governing how land could be used, we just had, when someone had a dispute, you brought it to the judge, and the judge told you who was right and who was wrong. And through that process of judge-made law, we developed certain principles, and we call those the common law principles. And what the common law traditionally said about land use was that one could do with their property whatever they wanted, so long as it wasn't, directly interfering with somebody else. Land use and zoning is stepping away from that general principle and is saying, no, we, the government, we, the people, through our elected government, are going to control what you can do with your property. We're going to take, we call property in law school, you're taught property is a bundle of sticks. And essentially, this is the government coming in and saying, yeah, I'm going to take a few of those sticks. And so what the courts have said is, okay, fine, government, you can do that. You can take some of those sticks, but you better be really clear about that. And to the extent that there's any ambiguity on that, we're going to default to the basic fundamental principle that someone can do with their property whatever they want because it's their property. Now, we're evolving a bit in the courts, and there are other principles that come into play, but I think when drafting an ordinance, it's important to keep that in mind, that the reason you need to be clear is because that default assumption is that there shouldn't be a law there. So you need to be crystal clear about what that law is. And if there's any ambiguity, you run the risk of a court interpreting that in favor of the developer. And so that's so another way of saying that is they're going to construe the ordinance very strictly. When we're dealing with land use ordinances, I think it's helpful as you're drafting to keep in mind the various players that will come into play with a land use ordinance. So, you know, any land use ordinance is typically going to vest, if there's a decision to be made, authority is typically going to be invested in either the code enforcement officer or the planning board. And then any appeals process, if you're going to have a local appeals process, is going to go before a ZBA or a zoning board of adjustment. Rarely, but not entirely uncommonly, your select board or councilors will play some role in a land use process. That's a bit unusual. Where you most typically see it is in contract zoning, which is a sort of form of legalized spot zoning, which I can talk a little bit about later. But the other major players that you have in any zoning discussion is you have the applicant who wants to do something with their property. You have the neighbors who maybe don't want to see that happen. And then the court is where this will end up if someone isn't happy with the decision that a municipality has reached on something. And so I think it's important in the drafting process to consider all these dynamics and how that's going to play out. And that's certainly a role that legal counsel can play coming in here, is to apply the laws that are being made in the courts and how the courts have interpreted other ordinances, and we can help you learn from the mistakes of what have happened in other municipalities in drafting your ordinances. So I'm gonna skip over that one. So we've talked about a lot of these. These are some of the tools that you can use within a land use ordinance. So as Matt was saying, the traditional and sort of your bedrock principle of a zoning ordinance would be to have, you know, your districts and then what uses are or are not permitted in those districts. But the statutes also allow things called special exceptions, contract and conditional zoning. These are different types of allowed uses that are allowed, but with a special exception, it's allowed so long as certain conditions are met. Contract zoning is something a bit getting more into that realm of performance zoning that we were discussing. Essentially, it acts as a legislative safety valve. So the idea is you in your municipality, you have zoned for certain uses in certain zones, but as William know, you try to be perfect, but you don't recognize certain things. Things change, as some of the presenters before were saying. Zoning ordinances should change, but sometimes it'll just be a particular property that so contract zoning comes up often. Let's say you have zone A, which is just for residential, and zone B is for commercial, and you've got someone who's sitting right on the border, and unlucky them, they got stuck in zone A, but now they want to have a gas station. And so they could either go through the entire zoning process and rezone their property, or some municipalities can choose to enact something called contract zoning, which allows them to apply for essentially a legal spot zoning, which is to get the zone of their property changed. Now, there are certain conditions that if you're going to do this in your ordinance, you have to have under state law that basically says it's not going to be such a dramatic change and so again, in the typical example of someone in zone A who wants to own a gas station, what they need to show is like, well, there's actually a couple grandfathered gas stations in zone A, and I'm right on the border of zone B. So it's not such a drastic change that it would constitute an illegal spot zoning. And so that's a sort of safety valve that you can build into an ordinance to give you some flexibility. I guess I'll talk about one of the choices you have to make, again, going back to the players, is with any particular use, who's going to be the decision maker there? And what I would suggest to you is that if you have a so site plan approval is something that you would pretty much exclusively only see a planning board doing. And this is basically that you have built in certain performance standards or conditions or criteria that a board evaluates to determine if they are or are not going to allow this particular project. So this is something that would typically be before a planning board, whereas you would see CEO approval, typically for something that's permitted, subject to CEO approval, and they're just confirming that certain non-discretionary standards like dimensional requirements and things of that nature are met. So another piece of your ordinance to consider are non-conforming lots and non-conforming uses. So what this is previously what people referred to, it's now considered a politically incorrect, or at least not ideal term, which is grandfathering or grandfathered lots. The appropriate term, if you want to use, is a lawfully pre-existing non-conforming lot or use. And what it is basically a lot or use that was legal before the zoning ordinance changed. And so non-conforming provisions in ordinances are used to basically prevent a takings claim, which is an argument that someone can bring when the law changes that says, I bought my property with an expectation that I could do something with my property. The law has now changed. You've taken that from me. You, government, owe me compensation under the Fifth Amendment of the Constitution. So a non-conforming provision is a way to get ahead of that issue and say, okay, we're changing the law, but if you had all your permits in place and you're doing this, you can continue to do that. But the catch is these non-conforming provisions will say, if you abandon that, or if you try to expand that, that may or may not be allowed, or it's going to be severely restricted. And the basic premise behind that is you want to gradually eliminate these non-conforming lots and uses. So, probably where I can be most useful here is the legal elements of an ordinance. So basically, this is what I'd consider the checklist of your basic land use ordinance provisions. Statement of authority, as we've previously discussed, Maine is a home rule state. So for most land use ordinances, statute 30A MRS 3001 will be the source of municipal authority, and that's as Matt was touching on, your general police powers. And so Maine being a home rule state means there's a presumption that a municipality is regulating something within its authority, and it's up to someone who is challenging them. They have the burden to show that this authority has been exceeded. And one of the ways that home rule authority is limited is through the doctrine of preemption. And so that's where the state has said, we're going to expressly say municipality can't regulate in this particular area, or LD 2003 is an example. The municipality has to do certain things when they regulate in this particular area. That's a check and a limitation on home rule authority. So in your statement of authority is where you want to, as a legislative body, point to what authority you're relying on to enact this particular ordinance. And part of your due diligence, and where you would involve legal counsel or your in-house staff or consultants, are to identify if there are any conflicts with what you're trying to regulate with state or federal law, so that you can be sure that you are regulating in an area that you do have authority to regulate in. Purpose statements. So this is probably, as a practitioner, one of the areas, particularly when I represent individuals or neighbors who are concerned about a development, they will almost inevitably always point out, be like, look at this purpose statement. You know, this says we're not supposed to have anything that's going to have an adverse effect on our neighborhood or be unduly or have too much noise, and we're supposed to protect the environment. And I always have to have a difficult conversation. I say, yeah, that's great. That's wonderful language that's in there, and it's completely useless to us. Because a purpose statement, the courts have made clear, is not a legally binding part of the ordinance. It's a useful part of the ordinance to help frame it, to help explain the legislative intent of the ordinance. And that goes to questions of interpretation and meaning and definitions. But when you are drafting, just keep in mind that anything in a purpose statement is not something that down the line, the planning board is going to be able to say, hey, this project can't be approved because it's inconsistent with our purpose statement. That's a great way to get flipped by a court. So just keep that in mind, that it's important, good interpretive tool, but it's not something where you want to put any of your substantive provisions of your ordinance. Definition section, I think, is probably, as a lawyer, that's one of the first places I look for in a land use ordinance. I'm pretty tactile still. I'm trying to be better about being paperless, but I'm not. And so when I get a new case, I'm going to print off that land use ordinance. I'm going to go take the definition section. I'm going to rip it right out, and I'm going to staple it and have it next to me as I'm reading that land use ordinance, because it's probably one of the most critical sections of the ordinance. And the reason is from it's one of the most challenging sections to write as well, because you are trying to anticipate all the possible ways someone could interpret this land use ordinance you've written, and you're trying to make sure that you're thinking of everything, and inevitably you'll miss something, but you try to make sure that you're defining all the terms that are really going to be relevant when someone is asking, is this use I am proposing allowed? And so think through those carefully, and when a land use ordinance is challenged, it's often challenged on the basis that it's ambiguous, and a developer or a opponent, can't figure out what the meaning of a particular term is. And so the danger there is that, to the extent that a municipality is resting its decision based on a standard that's ambiguous, that decision is at risk of being flipped in court and sent back to the municipality. And that's just a very costly process from a development perspective. It may, if you have an ordinance that doesn't have great definitions, ill-defined standards, that may deter development, because a developer is going to look at that and go, well, that puts me at risk of having my permit challenged by a neighbor, and I'm going to go before a planning board, and there's not much certainty as to where they're going to come down here because these terms are not defined. Your next section is your basic requirements or prohibitions. That's just your, a use is allowed if it is in this table of uses, something as simple as that. Or if it's an ordinance that's more specific to a particular type of use, it may define, when a permit is or is not required, or when certain performance standards kick in. Something that you'll see in some ordinances, but not all ordinances, is a statement that unless a use is explicitly allowed, it is not permitted. If an ordinance has that, then you've got to find your use within the table of uses. If you can't find it there, it's not allowed. But absent a provision like that, the default is, again, you construe an ordinance strictly. So If something's not in an ordinance, it doesn't necessarily mean it's a prohibited use unless you have language like that. So I think that's a key consideration there. Again, the designation of the decision maker. Who is this a permit that a code enforcement officer is going to issue? Is this a permit that a planning board is going to issue? General rule of thumb, if you're going to have standards that give some degree of discretion, such as the use should have no undue adverse impact on water quality, that's something where really it's more appropriate to have a planning board process as opposed to a code enforcement officer, because where you have those discretionary standards, you'll typically be accepting evidence. There may be evidence from multiple parties. And so really you need to hold a hearing to be able to afford everybody proper due process in that scenario. One of the challenges that municipalities can get themselves in is particularly some older ordinances that haven't been updated will have the CEO issuing permits that are really discretionary in nature or have some of those discretionary standards. And the challenge there is that the CEO is not holding a de novo hearing. So if that gets challenged, there's no findings of fact for a subsequent reviewing body to get into. So you'll see cases where sometimes they'll start with the CEO decision, but because the land use ordinance doesn't ever give an intermediate body like a board of appeals an opportunity to hold a new hearing on that, it'll go all the way up to court, only for the court to say, I don't know what the CEO originally said, and send it all the way back to the CEO. So I think it's critical in drafting, if you're going to have any of those discretionary substantive standards, to put that before a body that's going to hold a de novo hearing and hear from all sides and give them an opportunity to be heard and result in clear factual findings that a subsequent appellate body can review. Application fees, general rule of thumb is they must be related to the actual cost and labor that's involved in reviewing this decision. So don't use these as a revenue tool, and don't use application fees as a way to essentially prohibit the use. You know, sure, gravel operations are permitted in Zone A so long as they file an application fee of $1 million. That's not going to withstand review, because I don't think there's a reasonable connection to the application fee to the process. One things that municipalities often regret including, and after my office is involved, they go back and amend their ordinances to include, is to include a provision that the town can choose to hire experts, independent engineers, legal counsel, for an application. And so that way, when you get a contested application or a highly technical application, at least the town's fees and costs involved in reviewing that application are covered by the applicant who's bringing it before them. So standards to govern the decision making, you can have different standards. You can have performance standards that say under what conditions a use can be allowed. Again, this would be something like it cannot have an undue adverse impact on water quality or on archaeological resources. Those are standards that, again, give boards some discretion to make a judgment call as to when something is permitted or not. Whereas conditions, generally speaking, are less discretionary. They're more along the lines of, if you propose this type of use, then this use is allowed subject to these particular requirements. And so the role then for the planning board is not so much to make a discretionary decision as to confirm, has the applicant in fact submitted a site plan that shows that a gravel road is going to be X number of feet wide, and provided the requisite evidence that some degree of maintenance will occur in accordance with this condition. A key factor in the drafting process is that you need to make sure that your conditions are as reasonably clear as possible and don't give unfettered discretion to your planning board. This is the principle that under the law that you cannot delegate legislative authority. Essentially, you can't go tell your planning board to decide. You can't have a standard. One of the classics is there was an ordinance that said, the proposed use will not interfere with the scenic beauty of the town. That sounds nice, and to a degree you may know what it means, but the court has said that that is too vague, and it essentially gives the decision-making authority over when a use is or is not allowed to the planning board, and that is dangerous because it opens it up to arbitrary decision-making. So general rule of thumb is that your standard, to the extent that it can be qualified or quantified, do that. An example is if you're going to have a noise standard, you can't just say something that the project can't be noisy. Have something to the effect of cannot have an undue impact on noise, consistent with DEP has quantifiable standards for noise for, say, gravel quarry projects. So that's a way to ensure that your performance conditions would be able to withstand judicial review. So the problem is if you have ordinance standards that are fuzzy, like that scenic beauty standard, it leaves the project open to being successfully challenged in court. So your enactment process, 30A MRS 3002 lays out the process for a zoning ordinance. If you're doing zoning, most critical part is that you have to have a comprehensive plan in place first, and your land use ordinance needs to be consistent with that. With a zoning ordinance, again, there's certain public hearing requirements that apply, certain notice requirements that apply, and you must have the map adopted at the same time as the zoning ordinance. Certain statutes, certain topics under the general category of land use are going to have a specific statutory process. Again, this is bring in legal counsel to go over the enactment procedure on that. If you're a charter municipality or already have existing ordinances, there may be an amendment process within the ordinance or charter. So you need to consult that process to ensure it's followed. In a town meeting form of government, though that really I think it holds true for most councils as well, but critical piece in the enactment process is that a ordinance, unlike a general article, cannot be amended on the floor of a town meeting. So if you want to have public input on an ordinance, you need to hold public hearings before you actually put it to a vote, so that you can incorporate that feedback into your ordinance, make any changes, and then call the town meeting for it to be enacted. As town attorneys, we often get questions about retroactivity. So under the default under a law is that an ordinance will not be will not apply to anything that is a pending proceeding, which means an application that's undergone some degree of substantive review. Typically, this is something past the completeness determination. However, this general rule can be overridden. In other words, an ordinance can apply retroactively, but you need to have very clear language, and there's some case law specifying what exactly that language is. So if you're going to have a retroactive ordinance, this is certainly one that you want to have legal counsel review carefully, because particularly if you have a specific project in mind that you're trying to target with a retroactive ordinance, there are considerations of vested rights, which is the concept that someone who has relied on certain approval processes or has gotten so far in a process and they have relied on that and made investments based on their permit, it cannot be subsequently revoked. by the town, but that's really a case-by-case scenario that involves an analysis of the facts. So that's absolutely an area that you want to consult with legal counsel. So I'm going to turn to enforcement. And I'll just cover this really quickly because I see I've gone 20 minutes in. So purpose of enforcement is compliance, not revenue. General misconception I find a lot is that municipalities think they must have comprehensive planning and land use zoning to have any sort of code enforcement. And that's not true. Under the statutes, there's already plenty of really a significant amount of authority that a municipality has to regulate land use violations. So there's a junkyard statute, there's the dangerous buildings proceeding. So a municipality can remove buildings that are deemed dangerous in their communities. They don't need to have zoning or land use ordinances to do that. They can address public nuisances. They also have certain enforcement authority concerning gravel pits, cemeteries, burial sites. So, you know, a ordinance isn't the only way to control land use in a town. Statutes already give municipalities some degree of authority. You can also have violations concerning validly issued permit. You know, typically, you see this come up with if a project hasn't been completed within the time that's specified in the permit. Again, if you're going to have any enforcement over a validly issued permit, you're going to confront that vested rights issue again. So again, that's an area where you want to consult closely with legal counsel. In terms of violation of a land use ordinance process, principles to keep in mind: concept of prosecutorial discretion. Land use in Maine is a complaint-driven process, which means that, you know, you can have two neighbors living next to each other and one may do something unlawful and nothing happens, and the other one gets an enforcement action against them. And I think there can be a public perception that that's unfair, but the reality is the courts look at it and say, a town has prosecutorial discretion, and so long as they're not picking on someone because of some, you know, reasons of bias or discrimination, it's up to a town to decide when they are or not going to bring an enforcement action. Another key principle is that a land use ordinance may call for fines, but a town cannot actually collect fines until they have a court order. The general process for an enforcement begins with a warning, and you escalate it from there. Again, the goal is always compliance. So it typically starts with a verbal notice, moves on to a stop work. When you get to the point of a written notice, typically it's helpful to bring in legal counsel at this point, unless you've already worked with your town attorney to come up with a template for written notices, because there's certain information that needs to be in a written notice, and if it's not, it's going to prevent you from successfully enforcing this violation in court down the line. The basic principles is it needs to have a statement of the legal authority or jurisdiction that the enforcement's being conducted pursuant to. Needs to have a reference to the specific provisions being violated. It needs to describe the nature of the violation and time and place of any hearing to challenge that, and whether there is a right to challenge the decision that there's an enforcement violation. And then one of the key pieces for including that notice is that the Maine courts have fairly recently clarified that decision that there is a violation is an appealable action to your local Board of Appeals process, unless your ordinance says it's not. So that's something to consider in drafting, is whether you want enforcement decisions to be subject to an intermediate appeals process. One of the benefits of doing that is if you do have an intermediate appeals process and you do write a notice of violation that is clear and has all the provisions that you need, if the violator fails to appeal that, they could be what we call res judicata, or prevented from being able to argue that they didn't violate it in the first place. Because what we would say as town attorney is, look, we gave you a clear notice of violation. You had noticed that you had a right to appeal that decision. You failed to appeal that decision. So you now in court can't argue that you didn't violate it, because your opportunity to do that expired 30 days after the notice of violation. So that's the benefit of having a notice of violation that has all the criteria that the courts have spelled out. Finally, again, the goal is compliance. So 99% of land use violations that we get involved in as town attorneys end with consent agreements or consent decrees, which are basically an agreement with the municipality that the violator will take the appropriate corrective actions and some payment of fine and recovery of attorney's fees. I generally like to steer these towards consent decrees, because they are then entered into as a judgment of the court, and that makes it much easier to enforce down the line. There are also additional enforcement techniques available to CEOs, and that's something that you might consider in your land use ordinance. Just recap, role of legal counsel, I think, is key in the very beginning and the very end of the ordinance process, which I think is exactly what Matt laid out. But another role of legal counsel is when you are involved in a contentious planning board or board of appeals proceeding. It's a good idea to have legal counsel. It's while it may appear expensive at the time, it's a lot easier to address. Make sure that you have whatever the decision is, make sure it's a decision that's clear, so that it's not kicked back on a remand. I have some written materials that go into the rest of this, so I won't spend any more of anybody's time on these judicial considerations unless there's any questions. And I don't think I see any questions. So. All right. Well, thank you all for your time.
I have another slide, but it's not coming up. Oh, I added another slide for the survey, but it's not coming up, but that's okay. I sent a link in the chat to a survey about workshop topics. Thank you all for being here on this Wednesday evening. We'll send out a recording and the slides within the next week.